Okay, so this is my personal understanding or impressions of where we have come, and obviously the Act was just passed. And to be frank, every time I look at this 90-page document, I see new things that I didn't quite notice earlier. So no one's going to say that this is a magic bullet that it's going to make everything better, far from it, right? But I think it's important to talk about some basic, broad issues, and that's what I'll focus on in the 15 minutes that I have. Okay, well, for those of you who are new, well, maybe this might be useful, that we've gone through quite a few iterations of trying to address the issue of first regulating research in biomedical research, and more specifically ensuring to the best that we can that all research conducted is ethical, and it respects the interests and welfare of the persons that are asked to participate and make sacrifices on behalf of future generations or society in general. Now, so I've just put down some things here, but I think the point being that two or three important points. First is that for a long time we've operated simply with guidelines, but in a sense the guidelines had a certain bite because they were sort of force-fitted into pre-existing regulatory frameworks related to healthcare and the medical profession. And that's how they had perhaps more influence than pure guidelines. Okay? But for the longest time, clinical trials actually had a statutory basis, a legislative basis, under the Medicines Acts, the clinical trials regs. And as we'll see, our current framework as it appears is quite varied, right? It says Human Biomedical Research Act, but actually if you want to know what the legislative framework is, there are a lot of other things out there that you need to be aware of and how they may or may not work well with each other. Okay, so where we are today is that we now have what looks like a comprehensive piece of legislation. In the pipeline also, I understand, and it's public, right, so I'm not revealing anything I'm not supposed to, that the new clinical trials regs will also be promulgated at some time soon for public consult. Right, and coincidentally, also this year, the BAC has issued a sort of a compendium ethics guidelines of human biomedical research, which also took into account at least the draft bills that were proposed for HBRA. So one way to start is actually to say what is the regulated universe, and although each statute stands on its own, the most comprehensive definition you're going to find is actually now under the HBRA 2015, Section 3, which I sort of very tried to simplify it. It spans 2 pages. You have actually a main set, which is a purposive limb, what the research is for, and then it's combined in various combinations, permutations with an activity limb. So, as long as it studies disease, disorder, or injury, aesthetic appearance, or performance and endurance of human individuals, and whether it involves a physical, mental, or psychological intervention, significantly only individually identifiable human biological material or health information, will it fall within the main scope of the definition. Okay. Now, it's pretty wide, and there are some qualifications later. And there are also these specific categories. And well, I just reproduced the list there. The short form is some form of sensitive tissue or hybrid combinations of tissue, human-animal combinations. So even if it is de-identified under the first limb and may fall out, it would fall back in if it fills one of these status requirements. Okay. And of course, the Act itself does exclude some categories under the second schedule. And an important one is actually clinical trials themselves, which would fall within the main definition, but are excluded because they are regulated under a different set of legislation. Okay, so, well, this is how do I put it all in one slide? You have the main Act, right? And it basically sets out the main framework for what the regulatory system is going to be like for human biomedical research. The Act is out, but actually nothing else is out yet. So there's envisaged lots of subsidiary legislation that will govern more specific points. None of that is actually out yet. And there are also, as Dawn mentioned earlier, there are also these important provisions for codes of practice or ethics, which may be issued by the regulatory authority or adopted, right? Of course, that's always very useful when you don't want to do the work yourself, you just adopt someone's guidelines, and that makes life a bit easier. But for clinical trials, there's a separate system, but actually, as I'll mention shortly, it actually interacts with this at some points, right? So you have the Medicines Act currently, right? What they're going to do is they use this word port, they transfer the regulations to the new Health Products Act. You've had this long-standing Singapore Guideline for Good Clinical Practice, which is based on the ICH document with local modifications. You also have guidelines issued by the National Medical Ethics Committee that pertain to clinical trials. And why this features? Well, because under the current definition of a clinical trial, it must be conducted by a doctor or dentist. The person who holds the CTC must be. I'm not sure that's going to be the case in the future, but so long as that's the case, then these professional guidelines would have some persuasive or moral authority. And a very important one issued by the NMEC is actually on phase 1 trials and the provisions that you have to have for phase 1 participants. Okay, so this is all contingent because once the entire regime is transferred to the Health Products Act, then we'll have to look carefully at how that framework stands. But the immediate thing I can say about this is that I think it's envisaged that this system will rely on HBRA IRBs to review the ethics of the clinical trial. That is the current practice, and I don't see a whole separate set of IRBs being created specifically for clinical trials under a different regime. So I hope they sort those things out. Right? So it's not completely separate, but it's meant to be governed by different regimes. Now, on the point of tissue, again, the HBRA is not going to be completely exclusive because it will work in tandem with another older piece of legislation, the Medical Therapy Education and Research Act, which deals principally with cadaveric tissues, whether donated or collected for, as it says, therapy, research, or education. And well, I'll say a bit more if I have time later, but basically, if you're talking about cadaveric tissue, there are actually two sets of provisions, one in the HBRA and one in the MTERA, and they apply in different circumstances. But a lot of it has been aligned in terms of the kinds of consents that are required, but they apply to different scenarios. Now, of course, there is other relevant legislation if we're talking about what is defined as human biomedical research, and that one stopping point would be the Human Cloning and Other Prohibited Practices Act. So if you're dealing with embryos and all that, there are certain absolute prohibitions under the Act that you have to be aware of that are not in the HBRA but in this. Okay. Now, and this is probably a whole conference on its own. I mean, just listening to what's going on in the past 2 days, health information, biodata banks would implicate probably more the Personal Data Protection Act, and perhaps less so the Human Biomedical Research. So these two have to be considered if you're looking at health data in the context of human biomedical research. This act has special exemptions from consent for the use of data, and so it would come under this regime. Special exemptions, which probably many of you are aware of, but if you're not, in one of the schedules, there are some exemptions for obtaining consent to using health data for research. But the important thing is that the concept of what is personal, or in this act, individually identifiable data has been aligned, so the definitions are the same. It's just that they both have to be worked out insofar as they apply in the HBRA context. Okay, so I hope, I just want to, the main point here is to avoid the illusion that with one big act, everything else sort of falls away. No, it's meant to work in a very evolving by accretion system, right? We just add on new layers. So, given that I don't have much time, I'm really not sure how much I can cover, but I sort of just want to pick out some broad issues. and in a sense emphasize what difference the new act might make to the regulatory framework. So as Dawn has mentioned, also the keystone or capstone, depending on how much you think consent can do the ethical work in research ethics. This is known as appropriate consent as far as the regulatory requirements are concerned, right? So there's a specific concept of appropriate consent under the Act. You can find the basic features in Section 6. There are, writing requirements, but there's no requirement that they take it home. I just wanted to highlight that for many years we've labored under a lot of legal uncertainty about whether you can take what kind of consent from certain individuals, adults who lack decision-making capacity, and minors. Okay, it's children and minors. Okay, 5 minutes, great. Suffice to say that prior to this act, as a lawyer, I couldn't tell you with certainty whether that consent that you thought you were relying on based on the US common rule would actually be recognized in Singapore. So I think this is an important contribution, that this act makes clear what is legally or regulatorily relevant consent for the purposes of involving people who can't make their own decisions. Okay, there are a few substantive requirements that are now expressed, but they can be supplemented by subsidiary legislation. An interesting feature is the concept of dual consent. I think I've seen it in Australia, but maybe not many other places. But we generally, the default rule is actually both, if the minor can make a relevant decision, has sufficient understanding and intelligence, consent has to be taken from that minor in addition to the parents. Now, any variations on this would involve some sort of waiver, but that's the default rule, right? So it's not an either-or position. It's actually both are supposed to be involved, and a whole host of ethical issues that arise from that construct. Okay, I'll just say that this is interesting usage that it uses the concept of sufficient understanding and intelligence, but it also uses the concept of lacks mental capacity. I honestly I'm not quite sure what the difference is, but we'll have to work it out. There are a whole host of disclosure requirements under Section 11 of the bill, and this is something that everyone has to read, because what it means is that you have to address certain informational categories if you're going to comply with the legislation. So it's important to read it because there are provisions on incidental findings and so forth. Okay. At some point, the word explain that does actually appear in the Act. And it's not just a sort of a bucket list or laundry list that as long as it's in the form I have disclosed and I've complied, there's actually, the word explain does appear in Section 6. And that's, again, I think where the ethics is going to go. How do we ensure that we explained this list of disclosure items to the individuals? So that's consent. Just be aware of what's new, what is clearer, and then what remains to be resolved. Now, in terms of the governance arrangements, anyone who's been involved in the existing systems will not be really surprised by this arrangement. What the legislation does is really to articulate some fundamental obligations in this tripartite relationship. I really don't want to go into too many things, but first for IRBs, there is an appeals process which you might want to, I'm not sure there is one in every institution right now, but the legislation provides for an appeal process. It also tries to facilitate multi-center research and try and reduce the paperwork by appointing one IRB for a multi-center trial. And the whole legislative scheme operates on a notify and declare compliance rather than a license model. So what it really means is that as long as you notify and you declare that you're in compliance, there's no pre-evaluation about whether you're worthy to be a research institution or an IRB, right? So it's sort of what they call this light touch. We're trying not to be too interventional, but we want you to make sure you comply with certain basic requirements. For RIs now, one important thing that hasn't been emphasized before is this idea of that there must be a certain localization of the RI. You can't be an RI based in the US, for example, and then engage individuals to do your research. You have to have a certain regulatory presence within Singapore. Otherwise, you will be in non-compliance with the Act, right? So that's something new meant to deal with the problem of international collaborations and the conduct of research. Okay, and so for RIs also, there's this notification and declaration requirements. So going back to the top, there are also special procedures, apart from the default. You get appropriate consent, you get IRB review. For certain categories of prohibited research, well, that's what it means. You can't do it. But more importantly, for restricted research, there are also provisions for the regulatory authority to prescribe a more rigorous or more exacting process, which might require, for example, approval by a central committee or a nationally appointed committee. What these are, we don't know yet, because again, it's the subject matter of subsidiary legislation. Okay, so the default processes are there, but there may be special processes that will be required for special categories of research. Okay, I'll just end off with what people find to be the scary bits, but there are some basic offenses that every researcher, RI and RB should be aware of. Well, they probably sound quite obvious. You can't compel someone. It's now an offense to compel someone by intimidation and so forth from participating in research. There is a duty to protect health information and human biomedical material from loss or unauthorized disclosure, and that's the criminal sanctions attached to that. There's a general prohibition from re-identification, and the reason for this is actually one of the regulatory lines is that if the information or tissue is de-identified, then it's out of scope. It's not regulated under this regime. So obviously, to protect the boundary, it is an offense for you to try and re-identify material in your hands that has been de-identified. And for IRB members, you should read section 29. There's now certain restrictions with criminal sanctions attached on disclosure of information by persons discharging functions under the HBR, including research review under section 29. I think I'll stop there, otherwise, yeah. So I want to talk about tissue, but we've got an even better expert who actually runs a tissue bank to talk about the tissue part of the Act. Thanks.
Right, thanks, Tracy.